The plaintiff's map has to be superior in your view under this new part, insofar as it uses race-neutral criteria. Is that what you mean?
Yes.
And that's what was asked for by Alabama. And so you'd be saying that that would require a change to what we said.
No, Alabama didn't argue that. The problem with what Alabama argued is Alabama basically said the plaintiffs had to come up in court and without considering race at all, somehow magically show up with the 50% district. We're not arguing that, and it didn't make much sense, so it's not surprising.
Oh, I thought they were saying you had to have race-neutral drawing. That was the whole thing about the computers.
No, so they had some weird thing about computers, which again,
no,
is not what we're arguing.
But it's crucial to this point. Their weird thing about computers was you have to demonstrate as the plaintiff that you have a race-neutral map, and that's what you're saying right now.
It's a very different thing. Yes, they both use the word race-neutral, but what Alabama did was something about computers that I frankly don't understand. What we are arguing is simply under the state's own principles,
right,
their map has to be better. That I do understand.
All right, and then my final question, it just goes to that point, because I'm struck by your, the degree to which your analysis relies on the state's departing from traditional principles. You say you get to Section 2 when they, Section 2 violation when they do that. And I guess I just wonder why that doesn't leave us in a position where you really cannot remedy the effects of race discrimination operating in a district based on past discriminatory choices. In other words, you're still bringing in intent because you're saying you have to intentionally depart from your traditional principles on the basis of race, and that's what's going to trigger Section 2. And I have, for example, the Louisiana historian's brief, where it talks about how the reason why you have blacks in different places is because the residential patterns in the state are still reflective of where enslaved communities lived along this particular river system. And that residential segregation, along with disparities in political power, economic status, health outcomes, all of these things are existent today because they reflect institutional choices that are traceable to Jim Crow and reproduced through contemporary practices. That last part is a quote from them. So I appreciate that you want to say when the state comes with their new map, we have to look at the extent to which in drawing it, they have departed from traditional principles on racial grounds. What I'm suggesting is what do we do with the situation in which the state keeps presenting the same map? They're not departing, their map looks fine, but because of all of these race-based effects, because of the history of Jim Crow, which I appreciate happened a long time ago, but I'm positing, and Jingles allows for us to see where those effects are still occurring. I hear your test not allowing us to solve for that problem when the state is continuing to present the same map under circumstances in which people are not actually being able to have equal electoral opportunity.
So I guess I'll say three things about that, Your Honor. The first is, again, our position, it does not require intent. I agree that at step one, we're saying you have to consider race-neutral principles, but if they've departed from that, we think you could find liability based on the effect without making a finding that they did it for intentional discriminatory reasons. Now, second, you pointed to the fact that it's possible that these effects stem from long distance.
Can I just ask you, why do they have to depart? What if they just keep on doing the same thing? They're not changing the map. I thought Section 2's whole point was that you gotta offer a remedy, you gotta have a remedy where this thing is happening. So the well-intentioned state with no intent to discriminate says, the census has changed, this is where people live, but we're just gonna provide our same map. And if we can determine that that map, under those circumstances, is not providing for electoral opportunity, regardless of whether they've departed from traditional principles, I thought you had to solve for that.
And I guess our point is you don't.
You don't. It's only where they depart from traditional principles.
It's only where you could say that it's either intentionally or likely intentionally.
So intent does come in.
You don't have to prove it by a preponderance of the evidence.
I see.
It's any other results test.
Thank you.
Thank you.
Thank you, counsel.